My name is Kent Weichman. I'm here on behalf of the Family Law Section of the State Bar. This is the voluntary section of the State Bar, attorneys who practice family law. There are about 2,600 of them. It's not the State Bar itself. They have their own position in opposition to this bill. Our position is separate from that. The attorneys in our section represent mothers and fathers, custodial and non-custodial parents. We firmly oppose this bill because it's bad for children. It's bad for children because it treats them like objects. Children are human beings. Their needs and their interests deserve to be taken into account. This bill explicitly bypasses the best interests. That you don't look at what's good for children in these situations. You simply decide in all cases to have one solution. The bill would mandate equal physical custody, equal time with each parent in every case where the parents live in the same school district, unless you're able to find, by clear and convincing evidence, that one parent is unfit. Only at that point would you even consider the best interests of the children. There are a number of problems with this approach. There are reasons that the court differentiates in the placement of children in custody cases. For instance, if you had a case where the child is becoming despondent or even suicidal in going back and forth all the time, under this bill, that's irrelevant. That has nothing to do with parental unfitness. The court would, if you presented that testimony to the court would have to say, I'm sorry, that's irrelevant. If you mentioned that the child had a strong preference to do something else, I'm sorry, that's irrelevant. If you showed that the school performance of the child was deteriorating, the child was flunking out of school, that's not relevant. It has nothing to do with parental fitness. That's just a problem for the child. If there is evidence that one parent is disparaging the child, that the parent always calls the child fatty or porky, it's not relevant. If one parent spends all the time that the child is in their household disparaging the other parent, something that would very much pain a child, not relevant. Right? What does that have to do with it? It's just anything. If one parent marries a pedophile, not relevant. Doesn't have to do with that parent's unfitness. You can go on and on. I mean, there are cases now where we have supervised parenting time. That the time a child spends with a parent has to be supervised. That's not an unfit parent. If you have an unfit parent, if you're able to prove what this bill requires, clear and convincing evidence that a parent is unfit, that results in termination of parental rights. It means even if you're not divorced, you would still terminate that parent's parental rights. The child would have no contact with that parent whatsoever. So even in a case where there's supervised visitation, that's not an unfit parent. It's a parent that's very troubled, who's having a lot of difficulty with the relationship. Under this bill, 50-50, equal time with that parent. Mandated, no choice on that. Just basically says the child doesn't count. What's good for the child, we don't count. Another problem with the bill is that it mandates one solution for all Michigan families. It's a form of social engineering that says there's only one way. When you talk about, we want both parents, we have both good parents, we want both of them involved with the child. There are all kinds of ways to accomplish that. Parents work out, when parents are focusing on the interests of their children, they can work out a 1/3, 2/3. Sometimes the child's in one household during the weekdays, the other household during the weekends. The child may spend a lot of summer and vacation with one parent, spend more of the school year with the other parent. There are hundreds of ways people work out what's best for their children. This says there is one solution. It is mandated. The only way, apparently the testimony seems to be, the only way you can have a relationship with your children and still be involved with your children is to have absolutely equal time. If you only have 40% of the time, that blows your relationship somehow. That's just not true. That's not what happens. There are parents who are profoundly part of their children's lives with all kinds of different relationships. And when parents work this out on their own, the 50-50 arrangement is fairly rare. That rarely works out for their children. That's not what people in Michigan are doing now. And to mandate it, to say, we know best, we are the government, we know what's best for all of your families, and it is one solution and one solution only, and that's what we're mandating, is wrong. It's not respectful to families. Even within families, there are a lot of families that find that different children adapt to transitions differently. And you'll see a lot of families that will have one pattern for one child and a different pattern for another child, because families themselves recognize children are different. Each child is an individual human being that should be treated with some respect and care. And so even within families, people will realize for one child this pattern works, for another child it doesn't. It says, we don't care. All children are the same. We're treating them all like objects. They're all going to be divided exactly 50-50, regardless of what they're like or what their pattern is. I think I mentioned before that the unfitness standard in this bill is just wildly inappropriate for custody decisions. Clear and convincing evidence of unfitness is what they use in juvenile court when they are proceeding to terminate parental rights. This is cases where parents are breaking children's arms, and these are the cases where you find children dead eventually, right? We get on social services for not, protective services for not intervening earlier in these kind of cases. That's what parental unfitness is, and that has to be proven by clear and convincing evidence. That's not a standard for determining what's best for children. That's a standard for children's survival. That's not a standard for working out what's best for them. The other problem with the unfitness standard is it changes the focus on custody cases. That right now what the court works with is a gender-neutral standard that looks at things like what are the children's bonds with each parent, who are they closest to, things like that, what are the parents' parenting abilities, what's going to work out well in terms of scheduling for the child, what are the child's activities, things like that. This says we're not looking at any of that. We're going to focus on who's a bad person. And so if someone has to bring this to court, the focus is going to be mudslinging as much as possible from one parent to the other, which is the worst possible result. This is what we've worked so hard over the years to eliminate, is to get away from the mudslinging and denigration of each parent. See, this is funny. The last time I mentioned actually focusing on best interests of the children, I got a hail of laughter from the room, because nothing is funnier than the best interests of the children. Focusing on that is just amusing. Why don't we just get back to the mudslinging arguments, going after each parent, and attacking each other? We work so hard to get away from that if there's a hearing about what we should do for our child, it should be what's best for our child. What can we do to make this better for our child? How can we arrange a schedule to make the child successful? So who does this bill benefit? Well, it doesn't benefit children. They're treated like property. We're not even going to look at their interests in this. Not mainstream parents. Mainstream parents are working out now agreements, 40-60, 1/3, 2/3, whatever works for them. Mainstream parents are not being excluded from their children's lives. They're spending substantial time with their children and having tremendous involvement. This helps bad parents and disinterested parents. The worse you are as a parent, the more likely that in court you're going to be given very limited or even supervised time with your child, the more this bill helps you, because you're absolutely entitled. You have a right to equal time with your child. Or if you're disinterested, say that it's a parenting case where you father a child, you have no interest in your child whatsoever. This bill helps you tremendously. You are entitled to have time with your child. That's a right, it's not a responsibility. You don't actually have to exercise it. You don't have to have your child with you at all. Your child support is immediately cut at least in half, because you have 50% of the time with your child. Plus the other parent has to pay you for the time that the child is supposed to be with you. So if the other parent is making more money, you actually get child support on the basis of this bill without having to spend a day with your child. That's a tremendous benefit to disinterested parents, to parents who have poor parenting skills, to parents who have bad relationships with their children. All of those people, this bill benefits. And I can understand why they would want such a bill. It is bad for children. It says that we ignore children's interests. It doesn't allow children to be in a position where we concentrate on what helps them. I just want to make one mention of the constitutional issue, only because it's been mentioned so much. I think this is, I don't want to term it frivolous, but if this were really a constitutional issue, these cases, it has not been my experience that people will not take these issues up in the Supreme Court.